from all the rights of the Bill of Rights. And you will recall, and this is part of your tutorial handy as well, so hopefully this is thoroughly cemented by the time that you get there. The primary obligation is to respect. What does that mean? It means hands off. And it means hands off in respect of also those traditional socio-economic rights where there is an existing entitlement, not to infringe upon that entitlement where that is not warranted and allowed in terms of law. Okay? Are we ready now? Okay. The secondary obligation is to protect. What does that mean? It means that there must be a proactive step taken by state institutions to protect the rights of people. So in other words, where you have a right that is existing under law, that the framework must be in place to allow you to exercise that right. So if the state has to protect my right to the maintaining of my good name or to keep you to your contracts, that legal framework within which I can do that must be maintained. Whether that is legislative or common law or customary law, but that must be maintained and protected. You understand what the protection part is? So in other words, there's a positive obligation to do something, and the something is to create a legal framework for the enforcement of rights. That's very important because obviously we recognize that human rights, for the main part, regulate the relationship between the individual and the state. But we also are well aware of the fact that private individuals or companies wield significant power. And therefore, for example, if I am in a dispute with my employer, my right in terms of Section 23, the protection of that right, requires that legislation must be put in place to ensure that I can enforce my rights as an employee against my employer. Okay, does that make sense? We've spoken about this before, and now we're moving on to the last aspect, and that is the obligation to promote and fulfill. When we talk about the promotion and fulfillment of rights, it's important that we bear in mind that different rights will require different steps to ensure the fulfillment and the promotion of a particular right. So, for example, if you look at your Constitution, you will see Section 29, in respect of basic education, is formulated in a very particular way. Section 28, in respect of children, is formulated in a very particular way. Section 28 says, for example, every child has the right to basic food and basic shelter and nutrition and food, or something along those lines. But what the important distinction is that I want you to pay attention to. Every child has the right to basic shelter. That's the part that I want you to focus on. Every child has the right to basic shelter. You and I, as adults, have the right, everyone has the right of access to housing, subject to available resources. And the state must ensure progressive realization of the right. Can you hear that? Promotion and fulfillment of your and my right of access to housing and the promotion and fulfillment of a child's right to shelter are two very different things. The promotion and the fulfillment of a child's right to shelter, or the basic education rights protected in Section 29, places a direct obligation on the state to do something. But if you read further, in Section 29, who's got a constitution that I could borrow? Sorry. Thank you. Section 29. And we will return to this in due course, but I want you to listen to this very carefully. Everyone has the right to a basic education, including adult basic education. Okay? Subsection B Everyone has the right to further education, which the state, through reasonable measures, must make progressively available and accessible. What does that tell us? It tells us that basic education and tertiary education are two different kettles of fish. For basic education, there's a direct obligation to immediate fulfillment of the right. When it comes to tertiary education, progressively reasonable measures over time within available resources. Different story altogether. So what I want to say here is what we have to bear in mind that there are textual differences. And those textual differences have a bearing as to the promotion and fulfillment obligation in respect to particular rights. For children, for the most part, the rights are directly fulfillable. And for the rest, progressive fulfillment will require measures over time within available resources to ensure realization of the right. Yes.
Isn't education still like a budgetary issue?
It is, but the difference is that what happens now, and there was this landmark case last week, on school infrastructure. The difference is that the legislature and the executive, the elected branch, they make legislation, they formulate policy. You litigate on the basis of the non-fulfillment of their legislation and their policy. So you say, because technically, if you go and look at the budget, the money is being allocated is available, which is not spent. But I agree with you, it does have budgetary implications, and of course, I'm not really all that excited about engaging in those types of cases, even though, for the most part, they've stepped up to the plate and made an order forcing the state, the elected branches, to fulfill their responsibilities. Now, we'll return to this in due course, particularly when we look at the direct application and two-stage approach. All rights may be limited, and this stems from what we've said before. If we have different obligations set for the state in respect of the different rights, the state must respect, protect, promote, and fulfill. That doesn't mean that they must do everything always to make sure that my right to dignity or that my right to freedom of movement is protected above yours and above anyone else's. All rights may be limited. And there are justifiable limitations and there are unjustifiable infringements. So I like to call what is justifiable a limitation and what is an infringement, because you cannot justify an infringement. Or you try and you fail because your test falls short. Then we also furthermore have to look at the textual formulation, and we'll return to this when we look at the specific rights. Some rights tell us this is what is included, this is what is not included. Section 16 of the Constitution tells us everyone has the right to freedom of expression, and it tells us a whole host of other things that freedom of the press and the media, academic freedom, blah, blah, blah. And then it goes on to say, freedom of expression does not extend to the following: advocating propaganda for war, incitement of violence, and hatred based on race, ethnicity, religion, or gender. So there's quite a clear delineation. This is what is protected, that is not protected. So when someone tries to make an argument, I'm going to say, incite propaganda for war, but that is protected under free expression. There's a very clear constitutional exclusion of protection. So that and legislation which limits the right of people to express themselves in that way is constitutionally a justifiable limitation of the right to freedom of expression. But we'll return to this, particularly when we looked at the different forms of application of the rights. So, when we look at respect, protect, promote, and fulfill, what have these obligations done for us? How can we read that general obligation that is set on the state to respect, protect, promote, and fulfill? How do we read that as impacting on what the state has to do? And I want to particularly look at two judgments. And the one is very familiar. You know it inside out, outside in, top, bottom, the whole bang shoot. Tell me about it. First one. It's the last of the Glenister judgment before Helen Suzman took over the litigation. The last of the Glenister judgment. What did the court say? What did Judge Cameron and Judge Moseneke say, and how did that contrast with what the minority of the court said in that regard, Judge Noble? Can you remember? You don't really want to, do you? Open the little folder, click, click, yellow folder, Glenister, take it out. The important thing that I want you to look at in this regard is the following. You remember Mr. Glenister had it on about the Scorpions replaced by the Hawks, and in the first instance he challenged the executive decision, then he challenged the legislative process, and he was unsuccessful. What did he challenge then? He challenged the validity of the legislation, and that's what this case is about. And Judge Moseneke and Judge Cameron, in their judgment, say the following. As we've seen, paragraph 175, and then I'll read a couple of other passages. It feels like a sermon to you as well. 175, as we've seen, corruption has a deleterious effect on the foundations of our constitutional democracy and the full enjoyment of fundamental rights. It disenables the state from respecting, promoting, fulfilling the rights as required by 7.2. Then it goes on in 177, and it goes on to 178, which I also want you to pay attention to. But 177, section 7.2, casts an especial duty on the state. It requires the state to respect, protect, promote, and fulfill the rights in the Bill of Rights. It is incontestable that corruption undermines the rights in the Bill of Rights and imperils democracy. To combat it requires an integrated and comprehensive response. The state's obligation to respect, protect, promote, and fulfill the rights in the Bill of Rights, thus inevitably, in the modern state, creates a duty to create an anti-corruption. So what do we see? What do the judges do with 7.2 here? Remember, Mr. Glenister's whole argument was the Hawks are not independent enough. Remember, that was the argument. So the judges in this particular instance say, section 7.2 says you must have an effect, in order to respect, protect, promote, and fulfill, there must be an effective crime fighting or anti-corruption unit. And an effective crime fighting, corruption countering unit is one that is independent. And independence, we can link to the international law standard on the Convention Against Corruption, and therefore it reads the obligation from that international law through section 7.2 into the obligation set by section 7.2 of the Constitution. Now if you contrast this with what Judge Noble says, and I trust that I have it here. Paragraph. Paragraph 105. As I understand it, okay, section 7.2 of the Constitution creates an obligation on the state to respect, protect, promote, and fulfill the rights in the Bill of Rights. This obligation goes beyond a mere negative obligation to act in a manner that would not infringe or restrict a right. Rather, it entails positive duties on the state to take deliberate and reasonable measures to give effect to all the rights in the Bill of Rights. And then, 107, under section 7.2, there are a number of ways in which the state can fulfill its obligation to protect its rights. The Constitution leaves the choice of the means to the state. How this obligation is fulfilled and the rate at which it must be fulfilled must necessarily depend on the nature of the right involved, the availability of resources, and whether there are other constitutional provisions that spell out how the right in question must be protected or given to it. But Judge Noble comes to the conclusion that what the majority of the court does is it uses section 7.2 as a backdoor to introduce an international law standard that actually does not directly apply in South African law. But I want you to particularly go and read Judge Moseneke and Judge Cameron so that you can see how they construe from Section 7.2. They deduce that there's an obligation to have an independent crime-fighting unit. And that, they then say, requires us to enforce the international standard. And to me, it does seem as if you're taking Section 7.2 and you're pushing and pulling it to do all sorts of things. Because Section 7.2 never says there must be an independent crime-fighting unit. But Section 7.2 says that there must be a respect, protect, promote, and fulfill obligation in respect of all the rights in the Bill of Rights. But can we take it to mean to go as far as they wanted to go? Or within the doctrine of separation of powers, do we have to agree with Judge Norwell that actually you have to look at are there specific provisions that relate to when international law is binding in South Africa? If there are, we have to follow those. We can't create a new avenue to introduce obligations through Section 7.2 that are not stipulated in the law or in the Constitution or in the law that is compatible with the Constitution. Does that make sense? And if it doesn't, revise it. Okay? And you could ask me again tomorrow, not tomorrow, Thursday. We can go over this. Because this is a more tricky case to illustrate the application of Section 7.2, but it also shows the elasticity of Section 7.2, and that potentially, yes, it is possible to stretch Section 7.2 probably a little bit beyond what it was intended for. Because what it actually does is it simply affirms positive and negative obligations in respect of all rights. It doesn't create a new avenue for introducing different standards that are not set out in the Constitution. Okay. Welcome High School. Do you know this case? Anyone? Remember? Heard of it? Yes.
Was it not about the policy where you couldn't exclude pregnant girls from school?
Yes. It was the pregnancy policy. Yes.
And then the school ignored that, and then it speaks to how you can't ignore policy, and it also ties in with non-arbitrariness.
Okay. Let's go back to the beginning and let's just fast forward a couple of years into your future when you're studying administrative law. Because we need to understand a little bit of administrative law in order to really make sense of the case. But it's exactly the case about the pregnancy policy. The Schools Act says every school has a school governing body. And on the school governing body, there's X, Y, Z, A, B, C, learners, teachers, the whole bang shoot. Parents. They make rules, a code of conduct for the schools. Among other things, they have the authority to establish a pregnancy policy. The school, Welcome High School, plus another school, somewhere in the Free State, had a policy that said a girl cannot return to school within the year that she gave birth. So if a girl gave birth in January, she had to wait until next year, January, to go back to school, in accordance with this policy. Okay? So the HOD, the head of Department of Basic Education in the Free State, said, over my dead body, this is not fair to the learners. Because there were a number of kids who were prevented. So they go back to the school, they say, here I am, I'm fit as a fiddle, I can go back to school. They say, when did you give birth? 2nd of January. Okay, come back. Okay, I'm obviously enriching just a bit. But okay. I'm not prone to exaggeration. So, parents complained. The head of department said, you have to take these kids back. But, in terms of the Schools Act, the head of department can only intervene after he has followed a particular procedure. The head of department cannot simply storm in and say, you are now going to be in that class and you're going to be in that class. Because the school governing body is respected as being representative of the will of the parents and the teachers and whatever, and is given and afforded respect in terms of the legislation. Ultimately, however, the head of department can stop the implementation of a particular policy, but it has to do it in a particular procedurally accessible, or procedurally fair fashion. In this particular instance, what happened was that the head of department simply went to the school and said, you are not enforcing this policy, you're taking these girls back. The school challenged that. And in the Constitutional Court, and this is the important judgment for our purposes, the court said, yes, indeed, administrative law principles require that where legislation says we can only challenge a policy if we follow the following 5 steps. You can only challenge a policy if you follow the following 5 steps. Even if the policy stinks like this one, you can't simply just brush it aside and do as you do. You have to comply with the procedures that are set up. But Judge Kampepe, who wrote for the court in this particular instance, really took a very solid approach in trying to balance, because on the one hand, following the procedure, following the rules is about the rule of law, and respect for the rights of learners. In paragraph 85 of the judgment, it is axiomatic that section 7.2 places an obligation on the HOD as an organ of state to protect the rights of learners. The question is how the HOD must exercise this obligation, and plainly, this obligation must be discharged in a constitutionally compliant manner. Section 7.2 must thus not be construed in isolation, but must be read with the other provisions of the Constitution. In particular, the obligation to protect must be read in the light of Section 1C of the Constitution, which states that the Republic of South Africa is one sovereign democratic state founded on the rule of law. The state's obligation must thus be discharged in accordance with the rule of law. The rule of law does not permit an organ of state to reach whatever may turn out to be a corrected outcome by any means. So the means do not, or the outcome do not necessarily justify the means. But the judge doesn't leave it there, and this is the important part of this judgment. She goes on to say, in sum, paragraph 90, it is so that the learners and their parents approached the Free State HOD when they felt that their rights and the rights of their children were violated. It is also true that the Free State HOD also owed them a duty of protection under Section 7.2 and was obliged to take steps to protect it. But it cannot be the case under that Section 7.2 means that he was entitled to do anything he wished to do to achieve the purported objective in addressing the unconstitutionality of the policy. The Schools Act offered the Free State HOD clear remedies to deal with that exact problem. But what the judge goes on to say in this particular case is she instructs the schools to revisit their policies, which she concludes are on the face of it unfairly discriminatory. And that's a very important balance struck between, on the one hand, upholding and protecting the rule of law, and on the other hand saying, well, yes, the HOD had fantastic intentions, but your fantastic intentions does not mean that you can disregard the law. So within the powers of the court to afford just and equitable relief, she said, okay, schools, go back to the drawing board. Your policies are a little bit dodgy. You have to look at them, you have to bring them in line with the Constitution. And as a result of the judgment then, we got the best of both worlds. We got compliance and protection ultimately with the rule of law, and compliance, respect, and protection of the rights of the learners affected by these policies. Okay, so can you see how the court can use Section 7.2 in quite a novel way to try and address rights infringements, but they do so always within the constraint of the rule of law. Whether that is the case in Glenister, I mean, I'm not entirely sure that I think Glenister's majority judgment is the best reading of Section 7.2. But 7.2 in this particular case really gives us an indication of the importance of the protection of rights, but within the constitutional framework. Okay, questions? Happy as Larry? Great. Okay, let's start with application. Okay, application of the Bill of Rights. We're going to spend quite a bit of time because what we're trying to do in this course is, first of all, get the general delimitate recipe. how do we operate and apply the Bill of Rights? And then we're going to do a whole lot of different sprinkles in relation to particular rights. Like twist the recipe a little bit so that we have a nice red velvet cake, we have a chocolate cake, we have a variety of other ones because we've twisted this basic recipe that we have and we are baking an ordinary old boring cake, so we are just adapting it so that it gives protection to particular rights that are set out in the Constitution. But before we can do that, we need to look very carefully at two things. I need to borrow the Constitution. Section 8 of the Constitution says the following. Okay, Section 2 says the Constitution says. Then Section 8 says, the Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. It goes on with 8.2, a provision of the Bill of Rights binds the natural or juristic person to the extent that it is applicable. 3 tells us how it does it, and 4 tells us about juristic persons. But the important thing that I want you to bear in mind is that on the one hand, we have a very explicit constitutional injunction to say this Bill of Rights applies to all law. Okay? And then we also have, when we talk about Section 39, which is the interpretation clause in the Bill of Rights, it says, when interpreting any legislation or when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. So we have very clearly an instruction in the Constitution to say that there is not one part of our law that is immune to constitutional reach. All law is bound by the Constitution. And then we get in 39.2, when interpreting legislation, the common law, customary law, we have to look at that common law, customary law legislation in the light of the values of the Bill of Rights. But what does that mean for our application of the Bill of Rights? It means the following. It means that we have to consider in the first instance how and when the Bill of Rights can apply, and we need to determine when it applies directly, who is bound and who is protected. Okay, what do we mean by how does the Bill of Rights apply? On the one hand, we have everyone has the right to, which gives you an entitlement, and typically that entitlement vests against the state. So a direct application is where I take my constitutional right, I rely on my right, and I go to court to enforce that right. Okay? Because I'm saying that the common law, customary law, legislation is unconstitutional. I place my reliance on a right. Indirect application is when you take Section 39.2 and you say, let's apply the common law or legislation in the light of the rights and the values in the Bill of Rights. Okay, we're going to unpack this in a little bit more detail. So we're going to look at how does the Bill of Rights apply, then we're going to look at direct application, and we're going to look at those two questions, but ultimately we're going to go through all the questions. So what I want you to do is get your head around the full question and then the sub-questions that we're going to answer. So the first sub-question is, what is the distinction between direct and indirect application of the Bill of Rights? Okay, you can get my notes. And two things preceding that question, and I ran ahead a little bit. First of all, we have to say, does the Bill of Rights apply? What do we know? We know that the Bill of Rights applies to all law, so it always applies. But how it always applies, that is the vexing and difficult question. So, we distinguish between direct and indirect application of the Bill of Rights. Okay. Direct application of the Bill of Rights. And the very important thing that we have to bear in mind here, this is like classification of rights. It's a useful tool, but this is not the be-all, end-all. Because as we go through this, you will see that the courts more and more rely on the notion of the application of the Bill of Rights as an overarching standard that informs and infuses every aspect of our law, rather than something that either applies in this way or in that way. So the court moves away from the binary. But the important thing is to start with the binary, and then we can question the binary. Okay, so it's a conceptual tool with different methodologies and different outcomes. That's important. Different methodologies and different outcomes. Direct application. You place reliance on a right, but not any old right, a Bill of Rights right. You challenge the validity of that law or legislation or common law or custom law. And you seek a declaration of invalidity that is rooted in the Constitution. Okay? So I allege that there is legislation that differentiates between men and women, and that is undermining my inherent equal dignity, protected by Section 9(3) of the Constitution. I challenge the validity of the legislation. I rely on my right to be protected from unfair discrimination. I challenge the validity of the legislation. I get a declaration of unconstitutionality. My remedy is rooted in the Constitution. Is that clear? So you're looking for right, law. You either say the law is unconstitutional or if someone's breached the constitutional duty, and your remedy is rooted in the Constitution. Okay. The alternative. You place reliance on the common law or legislation. So you do not place reliance directly on a right. But I say, in terms of this legislation, the Maintenance Act, in terms of the Domicile Act, in terms of any legislation, I place my reliance on the rights that are given to me in terms of the legislation. And I say, well, this legislation could be read in a way that is constitutionally compliant. And I think if we read it in a particular way to reflect the values of the Constitution, we don't need to strike this law down, but we can save it. So the remedy that you have is rooted in the legislation or the common law, but it is seen and interpreted in the light of the values of the Constitution. Shall we go over it again? Yes. Direct application. You have a right. Someone has an obligation. The state typically has the obligation. I have the right of access to housing. The state has the obligation to fulfill that right. They have enacted legislation to give effect to that right. I say, my right is infringed by the legislation that doesn't go far enough to give effect to my right. So I place reliance. I go to court, and this is a good one to remember it. So don't be married to this idea. I put the Constitution under my arm and I go to the court. And I say, this right of mine was breached by that conduct or this legislative act enacted that breaches my right. Strike it down. The remedy that is given to me has its roots in the Constitution. So the Constitution is central, and reliance on a right in the Constitution is central to direct application. Because the methodology is to find an inconsistency. The remedy is an declaration of invalidity rooted in the Constitution. Okay. Indirect application of the Bill of Rights. I place my reliance on the common law, the law of defamation. I place my reliance on legislation that affords me certain rights, the Maintenance Act. But instead of looking for an inconsistency between the right and the common law, or the right and the legislation, I say, oh well, the Constitution has a nice set of values. Let me put on that rosy-colored spectacle. I read the common law in the light of the values of the Constitution, and I interpret it in accordance with the values of the Constitution. My remedy, that which I want the court to order, is yes, you have defamed me. There's 10,000 rand to make you feel better. No, you didn't defame me. Or, yes, you are due to be receiving maintenance. You are entitled to 5,000 rand maintenance per month, whatever the case may be. But the common law and the legislation remain intact, but it is seen through a particular constitutional filter. Can you see that your remedy then stems from the common law or from the legislation? Your remedy does not stem from the Constitution. Because what you're actually doing is you're not applying the Constitution directly to show an inconsistency. You're using the values as a spectacle, a lens, to look at the common law, to look at the legislation, so that you can shake that legislation up a bit so that it is in compliance with the Constitution. Does that make sense? Okay. We're going to look at instances of direct and indirect application. But the first thing that we have to bear in mind when we look at direct application is who has obligations? Who is bound? So in other words, if I go to court, can I say, you infringed my right to freedom of expression because you told me to shut up? Or, alternatively, is there another aspect of our law that perhaps deals with it? And what we have to do is we need to apply the common law, we need to apply legislation, and we need to look at that legislation or common law through the lens of the Constitution. Okay, so who has direct obligations? Who must do and act under the Bill of Rights because they carry direct obligations in terms of the Bill of Rights? So, this leads us to the very vexing question, which we will also discuss again, between vertical and horizontal application. For those of you, sometimes like me, I'm challenged when it comes to direction, and I'm challenged sometimes when it comes to horizontal and vertical. This is the horizon. Okay? So if this is the horizon, this is vertical. Easy peasy lemon squeezy. Okay? So horizontal application is you and I are both private citizens. You and I are both companies. Can we read the Constitution to place an obligation on a company in respect of another company? Or a person in respect of another person? That is the question that we ask when we ask whether the Bill of Rights is directly, horizontally applicable. When we talk about vertical application, we talk about the legislature, the executive, the judiciary, how they relate to me, the citizen, or me, the company. Do I have rights, and to what extent can I enforce my rights directly against the legislature, the executive, the judiciary? Now the idea is, with the first formulation of the Bill of Rights, remember we said, what was recognized is, you are a little person, a peasant cultivating the lands. There's a king who just decides exactly as he pleases and does exactly as he pleases. If there's a way in which the law can protect you, primarily the idea was that king is going to be the one who exploits you. So the power, or the obligations in terms of a Bill of Rights primarily rested on the state. That is the traditional view. But horizontal application is an acknowledgement of the fact that there are power imbalances in society. And if there is a power imbalance in society, how do we address that? Can we say that the bank is much more powerful than me, and I have certain rights that must be protected, as opposed to the bank? And that's the question. But not any old rights, not common law rights, not statutory rights, rights under the Bill of Rights. And that is the question with direct horizontal application. But let's look then first at the easy part, which is section 8.1. And I've read section 8.1 earlier. And I'll stop after section 8.1 and then we can pick it up. It says very explicitly, the Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. So section 8.1 very clearly says all law is subject to the Bill of Rights. There's not a single aspect, single part of the law that is immune. And very importantly, it then lists legislature, executive, judiciary, and organs of state. Okay, so legislature, very quickly. That's all the legislatures that are elected by the citizenry after a general election or a provincial election or an election in a particular municipality. Now, the important thing that we have to bear in mind here is that the Bill of Rights is always applicable. It's not possible for the Parliament or the Makana Municipal Council or the Eastern Cape Legislature to press pause on the Bill of Rights at any given point and for any reason. Remember, what do legislatures do? Provide a forum for debate, keeps the executive accountable, elects officials, and makes laws. In all of those tasks, it is bound by the provisions of the Bill. Okay. And the Lil is a very good example of this. There are also a variety of other cases. DA versus Speaker is the case in relation to the security personnel deployed in Parliament. EFS versus Speaker is how you keep the executive accountable. So it's very clear that no Parliament, however bona fide or eminent in its membership, no President, however formidable be his reputation or scholarship, and no official, however efficient or well-meaning, can make any law or perform any act which is not sanctioned by the Constitution. It doesn't matter whether you are the Speaker of Parliament. It doesn't matter if you are the President. You cannot press pause and say, okay, today the Constitution and the Bill of Rights will not apply in this space. This space is constitutional. Nonsense. It's impossible. So the Bill of Rights applies and places a direct obligation. So I can go to court and I can say, Parliament failed in its constitutional obligation to keep the executive accountable, which is exactly what the EFF did, and had a finding in their favor. Now, you probably are not interested in listening to the rest of what I have to say, which pertains to the executive and the organs of state. Shall we just carry on here? But if I can, in the remaining 2 minutes available to me, please take the time to let the distinction between direct and indirect application sink in. Much depends